Welcome and thank you for joining today's webinar titled 2022 Mass-Peculiarities, Navigating the Complexities of Massachusetts Wage and Hour Law. All participants are in listen-only mode. You're encouraged to submit questions throughout the presentation using the Q&A feature in WebEx. If your question is not answered during the program, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Allison Silvera. Allison, you may begin.
Thanks, Dave. Hi, everyone. Thanks for attending today. As Dave said, my name is Allison Silvera. I am Senior Counsel in Seyfarth's Boston office. I'm joined today by Molly Mooney and Emily Miller, who are both associates in the Boston office and focus on wage and hour questions under employment law. If you've attended any of Seyfarth's recent webinars, as some of the major decisions that we're going to touch on today have come down from the SJC, you're probably already familiar with both of them and know how active they've been in staying ahead of many of the recent developments that we're going to touch on. Dave, can you go to the next slide? As most of you attending today likely already know, Massachusetts wage and hour law continues to present significant risks and pitfalls for employers operating in the Commonwealth, particularly where it diverts from and is more restrictive than federal law. Over the past 2 years, the Massachusetts SJC has issued a series of decisions that both reinforce that notion and create new challenges for employers operating in the Commonwealth. As a result, this spring, we published an updated version of our Massachusetts Peculiarities, which is Seyfarth's treatise on the wage and hour law in Massachusetts. For anyone who hasn't seen either past versions of the treatise or yet to receive a copy of the new edition, it's an incredibly useful desktop resource for anyone managing employees working in the Commonwealth. And the updated treatise represents hundreds of hours of work by Seyfarth's Boston attorneys under the leadership of Rob Fisher, a partner in the Boston office who unfortunately wasn't able to join us today, but really deserves all the credit for pulling together this new edition. And the updated version reflects the most recent, as of the time of publication, state of the law in Massachusetts. The complimentary book is available in hard copy or in an ebook. If you haven't received a copy of it and would like to receive one, please feel free to reach out to any of us after today's webinar, and we'd be happy to get you a copy. You can also order it yourself through the link that was provided both in the announcement for today's webinar and will be provided again in the next day or two when Seyfarth sends the slides for today's webinar, or you can go onto Seyfarth's website and order it directly there. Today's program is intended to focus on some of the more dramatic changes in Massachusetts wage and hour law since the last edition, focused primarily on highlighting the most broad-reaching SJC decisions and the impact of those decisions on wage and hour law in the Commonwealth, as well as the potential changes we see in the near horizon, and to highlight what employers need to do now. And Dave, if you can go to the agenda. We're going to start with, I'm going to cover joint employment and independent contractor misclassification or classification in the state, and then turn it over to Molly, who's going to talk about damages calculations for unpaid or underpaid wages. And then Emily will touch on the updated requirements around the payment of wages for Massachusetts employees, particularly in the retail and restaurant businesses. And at the end of the webinar, if we have time, we'll also touch on a few additional cases that have come down from the SJC since the last publication of Mass-Peculiarities, which are hopefully already familiar to you, but new to the treatise. Dave, can you go to the next slide? I don't know if we're having some technical trouble. Perfect. So the first case that we want to touch on today is the Jinx versus Credico decision. This decision came down last fall and was the first case from the SJC on the parameters of the joint employer analysis for employers in Massachusetts. Just by way of background, the case was brought by door-to-door salesmen who were working in Massachusetts. They alleged they were not properly paid minimum wage and overtime for all of the hours that they worked. And they sued not only the sales company that they worked for, but also Credico USA LLC, which is a sales brokerage firm that connected the sales companies for whom these employees worked with the customers who were looking to use door-to-door sales as an avenue of product promotion, but didn't have that internal capability. The employees sue, or the workers sued under Chapter 148B, which is the Massachusetts Independent Contractor Test. And their theory was that because Credico didn't treat them as employees, in fact, it didn't view them as having any working relationship with the brokerage firm whatsoever, it must instead have been treating them as independent contractors, and they were misclassified under the relevant test. Anyone who's familiar with the Massachusetts Independent Contractor Test knows that it's one of the hardest tests to satisfy in the country, second only to or equal to California. It's a conjunctive test, which looks at whether the employer can establish that the worker was not within its supervision or control, worked outside the putative employer's usual course of business, and was also engaged in an independently established trade or occupation. Unless an employer can establish all of those three factors, the worker is properly classified as an employee. And the plaintiff's theory in that case was trying to take this test on classification and fit it into a joint employer framework for whether two entities may be held liable for the same alleged wage violations. The court rejected this effort and found instead that in the type of arm's length business structure that presented in that case, the proper test for joint employment is the federal economic realities test. And that test looks at the whether the putative employer had the power to hire and fire, whether it supervised or controlled the work schedules and conditions of employment of the employee, determined the rate and method of payment, and maintained employment records. So really looking at day-to-day, how much control or supervision the putative employer had over the working conditions of the worker. In applying the economic realities test, the SJC recognized that a putative employer's actions intended to ensure quality and regulatory compliance are not indicia of supervision and control needed in prong 2. And that in order for the ABC test, the independent contractor test, to apply in any way to the employment relationship where there is a direct employer and a plaintiff is trying to bring in a second putative employer to be liable for the same wage violations, there must be, the plaintiff must present evidence of an intent to evade the wage laws. One other note on Jinx is, in that case, the plaintiffs were outside sales employees. Their claim was for both minimum wage and overtime as outside sales employees under Massachusetts law. There are actually 2 exemptions in Massachusetts law applicable to outside sales employees. There's an exemption for minimum wage and overtime requirements set by the Minimum Fair Wage Act if the worker regularly sells products away from the office and does not make daily visits to the office of the employer. And then there's a second exemption from the overtime requirements of the law if the worker is engaged as an outside salesman, similar to federal law. Prior to Jinx, there was not much case law interpreting these 2 statutory provisions, but in Jinx, the lower court recognized that the 2 exemptions recognized both exemptions as separate exemptions and held that the workers at issue were exempt from overtime. Because Credico wasn't an employer, the SJC didn't reach the question of whether they were also exempt from minimum wage as to Credico, but we expect to see some case law on that question. So the parameters of these outside sales exemptions in the minimum fair wage law in the coming months as the question is sort of percolating around the lower courts, which is important because even if a putative employer is deemed a joint employer, there may be no damages if the employee was an outside salesperson who was exempt or fell into any other categories of the exemptions in the minimum fair wage law and was exempt from minimum wage and overtime requirements of state law. Aside from the state test, which is a little bit more clear after Jinx, we also wanted to mention the federal joint employer test, which is Massachusetts Peculiarities, covers both the Massachusetts law and federal law to the extent there are distinctions. So we just wanted to point out that the joint employer test as a matter of federal law is currently in flux, and there's been major changes with it as a result of the presidency changes over the last decade or so. Under the Obama era, the DOL had issued regulations contemplating that a company could be considered a joint employer even if it had only indirect control or potential control, even if it didn't exercise that control over the workers, which was overturned standards that had been in place for decades as to joint employer, the joint employer test. The Trump DOL then rescinded those regulations and replaced them with a federal joint employment test that adopted the economic realities test we just discussed, with some additional employer-friendly nuances, including carving out the franchisee-franchisor relationship from the joint employment context. But then the Biden administration rescinded the Trump era regulations, and has yet to issue its own regulatory guidance. The NLRB has been sort of on a parallel track, and we do expect we may see some further guidance from the NLRB and possibly also the Biden DOL in the next few months. So stay tuned on what the federal test might look like. Right now, it's entirely unclear. So Dave, can we go to the next slide? The next case we wanted to touch on that also relates to the joint employer and independent contractor test in the Commonwealth is Patel versus 7-Eleven. Shortly after the Jinx decision came down, the SJC was again asked to consider the applicability of the ABC test to the independent contractor test to the concept of joint employment, this time in the context of the franchisee-franchisor relationship. And in early 2022, they answered a certified question from the First Circuit, which was focused on the interplay between the independent contractor test, where you have to establish that a worker is outside the control or supervision of the putative employer, with the FTC's franchise rule that requires franchisor control as an element of the franchise relationship. So the question in that case, which it's not the certified question, but the question that's still pending, is whether a franchisee who is not treated as an employer by the franchisor that it pays to operate a business using the franchisor's platform, again, because it's not treated in an employment context at all, is misclassified by the franchisor, which would leave the franchisor open to damages that come with misclassification. In that case, the claim is particularly ironic given that in a franchisee-franchisor context, the franchisee actually pays the franchisor, not vice versa. The SJC found that there was no conflict between the franchise rule and the ABC test, and distinguished the question of control by the franchisor over the franchisee's method of operation from the ABC test question of control over the services performed by the employee, taking a different lens to what the question of control is looking at, finding it's different under the FTC rules than it is under the ABC test. The SJC also refused to issue a blanket rule that the ABC test applies to determine the status of franchisee workers, finding instead that the analysis of whether the ABC test applies at all must be done on a case-by-case basis. We also saw in Patel v. 7-Eleven, the SJC confirming for the first time that regardless of the circumstances, whether the ABC test may be a proper employment test in the contractor versus employee, the employee first has to meet a threshold question, which is whether the alleged misclassified worker performed services for the putative employer at all. There's statutory language embedded in 148B that suggests a threshold inquiry into whether there's services performed, but the applicability of that language and how it was interpreted had not yet been analyzed by the SJC. So we do see that analysis in Patel, and the court states that an employee must show more than regulatory compliance and a mutual economic benefit, and it's the employee's burden to prove that they provided services to the putative employer. And this threshold inquiry will apply well beyond the just the franchisee-franchisor context, and again helps to put some parameters around the ABC test in Massachusetts and rein it in a little bit, which is what we see in both Jinx and Patel v. 7-Eleven, is the SJC starting to rein in a test that traditionally has been very challenging for employers in the Commonwealth to meet when they are working in an independent contractor and employee framework. Dave, can we go 2 slides ahead? I'm not sure what's going on with our PowerPoint today, so I'll just keep going, and at some point these slides will catch up, I think. The last thing that we wanted to focus on and highlight so back one, Dave. The last thing that we wanted to highlight is that there is some pending legislation, which may also, this is not in Mass-Pecs because it's new, but we wanted to highlight it on today's webinar. There is some pending legislation in Massachusetts, which could again alter the parameters around joint employer. In January of 2021, there was a bill proposed in the Massachusetts legislature after the Jinx decision came down from the trial court, but before it had been argued to the SJC. The act is called an Act to Prevent Wage Theft, promote employer accountability, and enhance public enforcement. There was a public hearing on it in the summer of 2021, and on April 4th of this year, the bill was reported favorably to the Committee on Labor and Workforce Development and is now pending before the House Ways and Means Committee. The primary focus of the bill is to define any violation of Massachusetts wage-related statutes as wage theft. So any violation of the prevailing wage statute, the Wage Act, the Independent Contractor Statute, the TIP statute, the prohibitions around staffing agency payment, and the minimum fair wage laws, minimum wage, overtime, any violation of any of those statutes, if this bill passes, will be defined in the Commonwealth as wage theft. And the focus of the public hearing on the bill was on the contractor industry. And the bill does talk about labor contractors and labor subcontractors, but as written, the bill expands well beyond that industry. The definitions as currently contemplated in the bill could apply to any business model that partners with other independent entities and holds such entities on the hook for this wage theft violations at any level of the relationship. If passed, it would create, in our view, could create a statutory definition of joint employer that we expect plaintiffs' lawyers would argue would directly undermine the economic realities test just announced by the SJC and Jinx. It's not much. That's not much of a consolation, but the impact would be somewhat limited. If an entity is a joint employer under Jinx, they're liable for 3 years. They could be liable for 3 years of alleged damages, trebled, plus interest and attorney's fees. If an entity is a joint employer under the proposed legislation, that liability would be limited to 120 days. And the legislation does contain a good faith exception if the putative employer properly investigates in response to any complaint, which would alleviate it from the treble damages and fees provisions. It goes without saying, though, that even if liability was somewhat limited, it could still have a major impact and exposure risk for employers in the Commonwealth who partner with other companies to do business. In addition to potential joint employment type liability for unpaid wages, the bill also contains other provisions that I just want to touch on quickly. First, for a direct employer who the AG finds may be liable for wage theft, the bill would authorize the Attorney General to issue a stop work order over the location where the underpayment of wages is occurring on just 5 days' notice, and set specific terms around the payment of wages to employees impacted by the shutdown. This would be appealable, but any employer who receives the stop work order must act promptly in response to the notice to avoid facility shutdown. Second, the bill contains a proposed public enforcement mechanism similar to, but arguably even more expansive than California's Private Attorney General's Act, which would permit an aggrieved person or a relator, which is defined to include not just current and former employees, but any vendor or client of the employer defendant with knowledge of the wage theft and wage statute violation, to bring a public enforcement action on behalf of all aggrieved persons. This is a little bit scary. It could be interpreted as currently drafted to mean somebody who's a client. Let's say you walk in, you buy a coffee, you're a client or a customer of Dunkin' Donuts or a coffee chain, and could you potentially bring a wage a public enforcement action if you suspect there's some wage theft or improper payment of wages at the location where you purchased a coffee. It requires 60 days notice to the AG, and the potential recovery for this type of action would be full treble damages plus attorney's fees, but only single damages to the aggrieved person. The remaining 2/3 of the award would go back to the state, with 50% going to the AG and 50% to a community outreach or labor education fund. It would be a way to bring a class action that doesn't require compliance with Rule 23 and potentially expose employers to large-scale wage disputes without needing to meet the requirements for maintaining a class action. We see it in California as currently drafted. This views the Massachusetts Public Enforcement Action Statute is a little bit broader than even California's PAGA because of the relator, the ability to bring a relator action, that you don't have to have a personal grievance in order to represent and bring the action. But maybe that will change before the bill goes any further. The bill does still face several rounds of debate and potential revisions before it goes to the governor for enactment. But what's clear, as we see it right now, is that the bill has many supporters and is likely to pass in some form. What can employers do to get ahead of some of this, particularly on the potential joint employer exposure, would be to have a dialogue with your business partners to ensure that they're taking all the steps necessary to ensure compliance with the Massachusetts wage laws, which are likely already doing post-Reuter, which Molly is going to talk about momentarily and is now up on the screen. If you could be deemed a joint employer under the proposed legislation, you may also benefit from a review of the indemnification provisions in contracts with any business partners to ensure that they clearly dictate which entity is responsible for any Wage Act compliance and any violations. With that, I'm going to turn it over to Molly, and I think you guys can probably already see one of Molly's PowerPoint screens up on the screen.
Great. Thank you so much, Allison. So yes, apologies to everybody for the technical issues. We are going to be distributing the PowerPoint after the presentation. So you will get to look at the slides. Sorry that you could not see Allison's section, but you have a little preview of what we're going to talk about now. So by now, many of you have heard about the SJC's April decision in Reuter versus City of Methuen, which has massive ramifications for Massachusetts employers with respect to damages for Wage Act violations. So just a little bit of background about that case. So the City of Methuen fired Beth Reuter, the plaintiff in that case, after she was convicted of larceny. And on her termination date, it didn't pay her accrued and unused vacation time. It paid that vacation time 3 weeks late. So neither party in that case disputed that the city had in fact violated the Wage Act when it paid her accrued vacation late. But the dispute was over what the proper measure of damages should be. So prior to the Reuter decision, there was longstanding precedent in Massachusetts that when wages are paid late, but paid before a plaintiff files a complaint, the only damages are interest on that delayed payment. So in the Reuter case, the city claimed that the only damages should be interest on the delayed payment of the vacation time. And the plaintiff claimed she was entitled to treble damages on the whole amount of the late paid vacation. So she filed a lawsuit and it went to a bench trial. The trial court agreed with the city. It found that the city had in fact violated the Wage Act, but the only damages were interest on the delayed payment. The trial court's decision was appealed, and the SJC completely changed course from prior precedent in Massachusetts when it issued its decision this April. So let's go to the next slide if we can. So when the SJC issued its decision, it held in Reuter that any Wage Act violation, even wages that are paid a single day late, result in treble damages. So in issuing this decision, the SJC rejected the reasoning of the courts that had established the prior precedent. And it said that essentially allowing for late payments made before litigation is started would essentially authorize and even encourage late payments right up to the filing of a complaint. So under this new standard, there is absolutely no wiggle room for mistakes. Whereas before, if you paid a day or two late, you could avoid treble damages liability as long as the employee was paid before they filed a complaint. And that option now is clearly off the table. Next slide, please. So I'm going to briefly discuss some of the ramifications and strategies for reducing exposure in light of the Reuter decision. But we've covered this topic in depth in a few recent webinars. So if this is something that you want to hear more about, please reach out and we can direct you to those resources. But briefly, again, Reuter has created immediate liability for treble damages for any violation of the Wage Act, even if the violation is corrected and the wages are paid. So what this means is Massachusetts employers really need to make sure that their payroll processes are solid. So you'll want to eliminate any room for mistake, errors, delay. So one of the times that this really becomes an issue is in the event of an employee termination. So as we know, if an employee is terminated involuntarily in Massachusetts, they must be paid their full wages on the day of termination. So employers will want to make sure before terminating an employee that their final pay is processed and ready to go. And the SJC in the Reuter decision actually addressed this issue. And they said that in the event of an employee who has engaged in, for example, illegal or harmful conduct, basically in the event where an employer needs to terminate an employee quickly, the employer might have to suspend that employee rather than terminate them for a short period of time in order to comply with the Wage Act requirements with respect to payment upon termination. So on that point also, last year, the First Circuit dealt with a case on this topic, and that decision is Nouse versus Broadridge Financial Solutions, which is discussed in our Mass-Pecs book. But in that case, the First Circuit dealt with an employee who had alleged to have been discharged for Wage Act purposes on the date that his employer informed him that his position was being eliminated. So essentially, an employer informs the employee that his position is being eliminated and his last day of work will be the following Friday. But at that meeting, the employer asked him to return his work laptop, remove work email from his phone. So essentially was relieving him of all duties. They were going to pay him for the remainder of his time, and his last day would be the next Friday. So he took the position in litigation that his date of discharge was the day he was informed of his position elimination. And the First Circuit rejected that. And it held that discharge under the Wage Act occurs when the employment relationship is severed. And that essentially it reasoned that the legislature could not have meant to punish employers who choose to give employees advance notice of the day that their pay and benefits will cease, and also pay them throughout that period. So both the SJC and the First Circuit have recognized that you can, in fact, essentially suspend employees in advance of their termination as a way to make sure that you are ready to issue their final pay on the day of discharge and to avoid the potential for triple liability there. So finally, on this slide, I want to briefly address the settlement of wage and hour claims in light of Reuter. So in 2012, the SJC issued a decision in Crocker versus Townsend Oil. And in that case, it held that in order for an employee to release claims or rights under the Wage Act, the release has to be plainly worded and understandable to the average individual, and it must specifically refer to the rights and claims that the employee is waiving. So any release of wage claims must specifically list the type of wage-related claims the employee is releasing in Massachusetts. And I bring this up because there was also a decision from Judge Talwani in the U.S. District Court last year, which also, this decision is also discussed in the Mass-Pecs book. But in that case, she analyzed whether a release that simply stated that the employee was releasing claims under, quote, local, state, and federal wage and hour laws was sufficient under Crocker. And she held that it wasn't. She held that even a specific reference to the Wage Act in a release isn't enough. It has to specifically identify the rights and claims under the Wage Act that the employee is waiving. So all of that is to say that any sort of settlement agreement, separation agreement in Massachusetts that is releasing wage-related claims or rights has to be very, very clear as to the wage claims and rights that that employee is releasing. And with respect to Reuter, it would seem that the best practice would likely be to include language that the employee is also releasing any claims for statutory damages, given the holding of Reuter. And we can move on to the next slide. So moving on from Reuter and its horrible outcome for employers, we have a little bit of good news with respect to damages for wage violations in the Devaney versus Zucchini Gold decision. So this decision came down in March of this year. And in that case, the plaintiffs worked for a restaurant called Rice Barn, and they were paid day rates and they were never paid overtime. So there were a lot of issues with how the plaintiffs in this case were paid. But ultimately, they brought suit under the Federal Fair Labor Standards Act for unpaid overtime. And they brought a claim under the Wage Act for failure to pay the FLSA overtime wages in a timely manner. They didn't bring a claim for unpaid overtime under the Massachusetts wage laws because restaurant workers are excluded from the Massachusetts overtime requirements. So the Massachusetts overtime exemptions are explained in detail in our Mass-Pecs book. It's an excellent resource on these exemptions and on these points. And this is important because Massachusetts has additional overtime exemptions that are not found under the federal law. So Massachusetts has adopted the federal definitions of executive, administrative, and professional employees, along with highly compensated employees, but it has its own exemptions for other categories of employees that aren't found under the federal law. So you heard Allison talking about the outside sales exemptions in Massachusetts. Those are two examples. There's some overlap with the federal law there, but it's also different. So Massachusetts also provides blanket exemptions for employees of certain businesses, and that includes hotels, motels, restaurants, hospitals, nursing homes, gas stations, and a few others. Those are all detailed in the publication. So in this case, the Devaney decision, the plaintiffs were restaurant workers and they were therefore exempt under Massachusetts law, but non-exempt under federal law. So the only damages in this case was unpaid overtime under the FLSA. So the trial court awarded that unpaid overtime at 1.5 times the regular rate, but then trebled those damages in accordance with the Wage Act. And so this appeal followed. And before the SJC, the plaintiffs argued that the phrase wages earned in the Wage Act included unpaid overtime damages under the FLSA, and that essentially, therefore, the Wage Act provides an alternative avenue of relief for violations of the FLSA. So essentially, you have unpaid overtime under the FLSA, well, we're going to treble it under the Wage Act. And the SJC said no. It said that the FLSA's remedial scheme preempts the Wage Act. So it held that where an employee's damages arise solely under the FLSA, that plaintiff is not entitled to elect to recover state Wage Act remedies. And so for employers with employees in any of those blanket exemption businesses, so hotels, restaurants, motels, gas stations, this is a really helpful decision because damages for unpaid overtime are limited to FLSA damages. And so the FLSA authorizes liquidated damages, so double damages. So you're dealing with double instead of triple. And under the FLSA, the statute of limitations is only 2 years, and it's only 3 years for willful violations, whereas under the Wage Act, it's 3 years for all violations. So you're dealing with a shorter period of time and only the potential for double damages. Also under the FLSA, there is a good faith defense to liquidated damages. So overall, you're dealing with the lower possible liability under the FLSA than the Wage Act. So obviously, this is really helpful. As we know, there is strict liability for treble damages under the Wage Act. And on that, I am going to pass it over to Emily, and you can go to the next slide.
Thanks, Molly. And we can actually keep going one more slide from here. Thank you. So first, we're going to just take a quick look at an update on Sunday and holiday premium pay requirements for retailers who are subject to the Massachusetts Blue laws. This is the requirement that certain retailers pay a higher rate to some employees for work performed on Sundays and certain holidays. And so even if you're on this webinar and the Blue laws do not apply to you, you may have heard about the fact that in Massachusetts, a covered employee working at a covered retailer on a Sunday is entitled to a higher wage rate to premium pay on Sunday because it is Sunday than they would make during their shift on Tuesday. And as those of you subject to the Blue laws likely know, Massachusetts has been phasing out premium pay over the last several years, and we are officially in the home stretch. The premium pay rate for calendar year 2022 is 1.1 times an employee's regular rate. And when we hit midnight at the end of the year, the premium pay requirement will evaporate. So that's right. There will be no more premium pay requirement in 2023. With just 5 months left, we do want to remind those of you subject to premium pay requirements of one particularly tricky stretch of terrain when it comes to the Blue laws. When you are calculating an employee's regular hourly rate for a week in which they work overtime, that's hours over 40 hours in a week, Under federal law, you may need to include any hours worked at the premium pay rate in that calculation for purposes of determining the employee's regular rate for purposes of determining overtime. So that means that an employee would have a different overtime rate in a week where they worked 0 hours at a premium rate versus a week when they worked even just 1 hour at a premium pay rate. And so we're not going to bore you with the math right now, but it's worth giving this section of the Mass-Peculiarities book a look. And then please reach out to us if you have any questions. And we can move on to the next slide. Now we want to talk a little bit about tipped employees. The 2020 amendments to the tip statute really created some buzz, where it had previously felt like there was a pretty bright line between which employees were tip eligible and which were not. The line got a little squishier with the amendments, and here's why. So instead of just asking which of my employees are tip eligible in general, employers should now consider asking which of my employees are tip eligible today, in large part because of the revision to the definition of waitstaff employee under the law. So employers with tipped employees had previously been cautioned against allowing any managers to dip into the tip pool. But with these 2020 amendments, an employee who serves beverages or prepared food directly to patrons or who clears tables and who works in a restaurant, banquet facility, or similar venue, and who has no managerial responsibility during a day in which the person serves the food or beverage or clears the tables, then that person is tip eligible. So the bold italicized portion on this slide, that's what's new with the amendments. So let's say you have someone with manager in their title, like an assistant manager, but with summer staffing issues because employees are on vacation, the assistant manager covers a server shift. During that shift, they perform server duties and they do not tend to any of their managerial responsibilities. That person may be tip eligible that day, even though typically they would not be. And so what we recommend as the safest course of action for employers here is to keep really solid records, clear records of who is working in what capacity during which shifts, and be clear with employees about who is tip eligible. And so in the assistant manager scenario that I described, make sure that if the restaurant gets slow, make sure that person knows that if they go in the back and start performing their manager duties, they're no longer tip eligible. They've performed manager duties during that day. And so even though they're otherwise mainly performing super duties, they've just rendered themselves ineligible. And so employers are in a position here where they could face a claim from typically tipped employees that someone who is ineligible dipped into the pool, or employers could face a claim from managers saying that they were denied tips on days when they were eligible under the law. And if you're not clear on whether an employee has managerial responsibilities, again, we urge you to consult the Mass-Peculiarities book and to get in touch with us. The test is not exactly the FLSA executive test, or it is not that test, I guess I should say. It's more of a case-by-case analysis based on the reality of your restaurant. But we can provide our analysis of current case law and help guide you with your input based on what these folks are doing on the ground. And then the other two categories of tipped employees here you see are service employees and service bartenders. Service employees are individuals who work in an occupation where employees customarily receive tips and who provide service directly to customers, but who work outside or food and beverage service. So they're not considered waitstaff employees, and who have no managerial responsibility. So the language as to service employees when it comes to managerial responsibilities looks like the pre-amended language as to waitstaff employees. So it's pretty safe to say that anyone who qualifies as a service employee, but who has any managerial responsibility at any time, would not be tip eligible under the tip statute. So the language, so for this category, just examples, we're thinking about hairdressers, cab drivers, bellhops, folks who customarily receive tips, but aren't working in food service. And then finally, this third category, service bartenders. These are folks who prepare beverages, whether alcoholic or not, for patrons to be served by another employee, like the waitstaff employees. And here there is no express managerial prohibition for individuals performing this type of work. There's just no mention of managerial responsibilities at all. We can move on to the next slide. On this slide, we want to talk about the difference between service charges and administrative fees and what steps employers should take to make sure that something that they intend to be an administrative or house fee does not end up being found to be a service charge that must be passed along to tipped employees. And so service charges are governed by the tip statute and they're passed along to tipped employees, whereas typically administrative fees are not. When faced with a fee on a contract or on an invoice, at bottom, the question here is, would a customer or a patron reasonably think that the fee is one that would be passed along to employees as a gratuity or a tip? And this makes sense, right? So if I'm having an event and my contract describes a fee in a way that makes me think I've already paid the gratuity, that it's included in the contract, and so I don't tip on top of that, then the tipped employee loses out on getting a tip because I was mistaken. And so in terms of a real life example, there's this case, Carpeneta versus Domino's Pizza out of the District of Massachusetts in 2014. And in this case, Domino's charged customers a $2.50 delivery charge that Domino's did not give to delivery drivers. And when a customer placed an order online, Domino's provided a disclaimer at the bottom of the page that said that the delivery charge did not constitute a tip. The court denied Domino's motion to dismiss and found that despite that disclaimer, that this did not constitute a tip, a reasonable customer could interpret the delivery charge as a tip. So if you're like me and you might have a Domino's app on your phone, you might see this language, delivery charge, and think, well, even if that's not as much as I would tip someone, I might be thinking, well, it's going to the driver, right? It's a delivery charge, but it's not. But because of this confusion that the court recognized, or potential confusion, I should say, as to the user and their understanding of where this money was going, they denied Domino's motion to dismiss in that case. The Massachusetts Appeals Court has interpreted the statute to require employers to provide an explicit disclaimer, notifying customers that an administrative fee is not a service charge. And as that Domino's example shows, the more explicit you can be, the better about exactly where the money is going and just being careful about what you call the fee. And we can move on to the next slide. Just for one other real life example of this in action, this case went up to the SJC on the question of whether tipped employees had a claim to a fee that was called an administrative fee in the event contract, but then was referred to as a service charge on the invoice. Reversing both of the lower courts, the SJC here held that these were service charges and that tipped employees had a claim to them. The thinking here was that the invoice language settled the patron's expectations. This is an example where someone gets the invoice and says, oh, the tip was included, so they may not tip on top of that. If there is any chance, well, the bottom line here, I guess, is that you should, or we would recommend that you check your receipts and other materials to just take a look at what you're telling customers about any fees that you're charging them that are not being passed along to tipped employees. If there's any chance that a patron does not tip because they think it's included, you may be vulnerable to a potential class action on this issue. And with that, we can move along to the next slide. And I believe I'm passing it back to Allison. I don't know if you're the first other update.
Nope, you're correct. Thanks, Emily.
Yep.
Before we hit the last section, I do want to announce the CLE code for today, which is SS4473. So again, that's S as in Sam, S as in Sam, 4473. So we wanted to touch on a few additional SJC decisions that have come down in between our last publication of Mass-Peculiarities and the 2022 edition. The last publication was in 2019. And so there are three decisions we wanted to highlight that you likely already know about, are aware of, have probably incorporated into your business, but you will see them highlighted now and described in more detail in Mass-Peculiarities 2022 edition. The first one is Sullivan versus Sleepies. This came out in May 2019, just after our last publication of Mass-Peculiarities. If you operate in an industry with workers who are paid on a commission basis, you're likely aware of the decision. But just to highlight it a little bit, prior to Sleepies, many industries in the Commonwealth paid inside sales employees on a commission basis. And there was guidance from the DLS in the form of 2 different opinion letters where the DLS had approved commission-only pay plans so long as the amount that employees earned in commissions exceeded the state's minimum wage and overtime requirements for all hours worked. So employees were being paid on a commission-only basis. Employers were checking and just confirming based on hours worked in a work week that the commissions the employee earned in that work week exceeded the amount that they would receive under minimum wage and overtime requirements of state law, and were under the belief that so long as the amount that was paid to the employee exceeded that amount, there was no additional compensation owed. But the SJC said no and upended these types of pay plans. And what the SJC found is that employees working on a commission basis were entitled to separate and additional compensation for overtime and premium hours worked. Emily talked a little bit about premium pay in the retail industry. So additional compensation employees have traditionally been paid for working Sundays and certain holidays over and above their regular hourly rates. This meant that while commissions could be used to satisfy the straight time portion of an employee's compensation, any premium compensation must be calculated and paid on top of commissions. So the additional compensation owed, whether now it's 0.1, 0.5 for overtime hours, that all has to be paid on top of and separate and additional to an employee's commissions earnings. There was a flurry of post-Sleepies litigation. I would put it in the hundreds, the number of cases that were filed by plaintiffs working in these industries looking for back wage compensation. Many of those cases have settled, but there are some still percolating that will continue to define the scope of Sleepies. There hasn't been an appellate decision yet interpreting the Sleepies decision. And some of the issues that are still live with many of employers, and now we're sort of to the point where a 3-year look back period is almost expired on the Sleepies decision itself. So some of this will kind of naturally fall by the wayside, but there was a question that hasn't been decided by an appellate court about the retroactive application of Sleepies. So if you've been paying for 3 full years under guidance from the DLS, under a commission-only pay plan, the SJC has rejected the DLS's opinions on this subject. Is the SJC's decision retroactive if you were complying previously with what the DLS had told you to do? And also a live question that arises from another recent SJC decision in Donis versus American Waste Services. This decision came out, I think it was in 2020, where the SJC considered whether a plaintiff seeking additional compensation through the Commonwealth's prevailing wage statute could assert their claim to that additional compensation under the Wage Act, and therefore the treble damages and attorney's fees provisions of the Wage Act, which don't exist in the prevailing wage statute. And the SJC found in that case that where the prevailing wage statute contains its own remedial provisions that often conflicted with the Wage Act, plaintiffs could not seek to avail themselves of the Wage Act's treble damages provision by asserting their exclusively prevailing wage claim under the Wage Act. The reason this argument is percolating in the post-Sleepies cases is because the only entitlement to premium compensation that plaintiffs are seeking, or the majority of the damages at issue in the Sleepies cases, often comes from that premium pay requirement, which arises under the blue laws that Emily talked about. And the blue laws, like the Prevailing Wage Act, contain their own remedial scheme. So can the Wage Act be used to recover wages that an employee is only entitled to because of the provisions of the blue laws and which have their own recovery separate and apart from the Wage Act. So that's why we mentioned Sleepies. It's still out there. If you're in the industry, my guess is you've heard about it, but we didn't want to omit to highlight it as one of the recent changes that's highlighted in Mass-Pecs. And then I think Emily's going to talk about the Meehan case.
Thanks, Allison. And so for this Meehan case, as many of you may be familiar, under the Massachusetts Personnel Records Law, an employee who disagrees with information in their personnel record can, absent reaching an agreement with their employer about removal or correction of some information in their file, the employee can submit a written statement explaining their position, which must then be included and become part of the employee's personnel record. So if I have a disciplinary issue a couple months ago, today I ask my employer to take a look at my personnel file. I get in there, I see my manager's account of what happened during that disciplinary issue, and I say, well, that's not right. Go to my employer, say, hey, can we revise this so that it's accurate in my view, or can we remove this? If they say no, I am entitled to submit my own written explanation of my disagreement with whatever it is that's in the file, and that then needs to be included in my personnel file. So in this case, the Meehan case, the SJC in 2021 held that terminating an employee for filing a written response to a personnel record violates the public policy exception to at-will employment, and that employee could sue for wrongful termination in that circumstance. So you can't fire someone because they submit one of these written responses that they're entitled to submit under the personnel record laws. Under the public policy exception, it is unlawful for an employer to terminate an employee in contravention of a well-defined public policy. And in Meehan, the SJC explained that the right of employees to submit those written statements in response to a personnel record is a legally guaranteed right of employment and a matter of public significance. So just a quick update on that Meehan decision from the SJC, and I will pass it over to Molly.
Great, thanks, Emily. So the last SJC decision we wanted to highlight was its 2020 decision in Parker versus Enornock. And this case dealt with damages on a Wage Act retaliation claim, and that claim related to a sales commission. So in that case, the plaintiff was a salesperson for Enornock and had closed a large deal. And the contract for that deal had a termination for convenience clause, which essentially gave the parties a one-time option to terminate the contract within the 30 days following the first anniversary of the effective date. So essentially, first year of the contract, then there's a 30-day period where the parties can cancel the contract. Now, the plaintiff's commission plan provided that on deals with such a clause, the plaintiff would earn a commission on the guaranteed portion of the contract, so essentially the first year of the contract, and then she'd be eligible to earn a true-up commission on the entire value of the contract if it survived past that opt-in 30-day period. So shortly after receiving her guaranteed commission on the guaranteed portion of the contract, the plaintiff complained about the commission that she was paid, and she contended that she was owed more than she was paid. And the company terminated her after she made her complaint. So she filed a Wage Act retaliation claim, and the trial court found that Enornock had retaliated against the plaintiff, so it had to turn to damages as what she was owed. So the Massachusetts Wage Act mandates treble damages for, quote, lost wages and other benefits. And commissions are considered wages under the Wage Act when they are due and payable and definitely determined. So in this case, the trial court awarded the plaintiff that she contended she was owed $25,000 on the guaranteed commission. So it awarded her the $25,000 on that commission trebled as lost wages. But then it also awarded her just the value of the true-up commission that she would have been eligible to earn had she not been terminated. And it did not treble the damages on that true-up commission because it reasoned that the true-up commission did not constitute lost wages because at the time of her termination, that commission wasn't definitely determined or due and payable because, again, she was terminated shortly after closing the deal. The true-up commission wouldn't have been due for over essentially a year from then. But the SJC disagreed with the trial court, and it held that the true-up commission was a lost wage subject to trebling. So it clarified that just because a commission is not due and payable or definitely determined does not mean that it's never a wage for purposes of the Wage Act. The SJC noted that the case law interpreting whether a commission is definitely determined and due and payable never contemplated whether unpaid commissions constitute lost wages resulting from retaliation. So the SJC explained that The clause defines when commissions become due to be paid promptly under the Act. Commissions that are not yet due to be paid may nonetheless constitute lost wages if the employer's violations of the Act prevent payment of those commissions. So essentially, the SJC reasoned here where the employer's actions prohibited and prevented that employee from earning that true-up commission, those were considered lost wages. So this holding is limited to the extent that it's dealing with damages on a Wage Act retaliation claim in a very specific circumstance, but we wanted to flag it because it's just another example of the SJC extending the reach of treble damages essentially wherever it can.
Thanks, Molly. So that's all that we had that we wanted to cover specifically from the updates in the Mass-Pecs treatise. As you can see, the SJC has been very active in the last few years, and we really just wanted to highlight some of the most important decisions. We do recognize that in the interim between 2019's Mass-Peculiarities publication and today, many things have changed about the way all of us do work as a result of the COVID-19 pandemic. We didn't focus on that today because we were focused on the treatise, which talks about the parameters of the Commonwealth's wage and hour laws themselves. But we anticipate that as we continue to see the effects of the pandemic on how everyone does work, there'll be more changes to how the laws are interpreted. We're actually working on a series of micro webinars right now that will focus on the impact of the COVID-19 pandemic on how we all do work and some of the ways that we interpret and apply the wage laws and employment laws in general to today's business environment, such as accommodation claims, statutory exemptions in the current sort of remote hybrid work from home environment. Be on the lookout for that series of micro webinars, which will start up this fall. And otherwise, that's everything we've prepared for today. Please do reach out to any of us if you have questions or need a copy of the treatise. We're happy to help. Thanks, everyone.
Thanks, everybody.